It's your
Now you
turn.
talk.
That's right. And so that way you can fake a conversation. But I'm guessing,
We should be coming up on it.
yeah, it's getting close. Welcome, everybody, to The Lawyer Show. I am your lawyer, Jeremy Rosenthal. And so on The Lawyer Show, what I wanted to talk about today before we really get going is that everybody knows that, and I don't talk a lot about spirituality. I don't talk a lot about the afterlife. I don't. Those are topics that I tend to try to avoid talking about and interacting about. But one thing I think we all know is certain: the straightest path to heaven is being a lawyer. All lawyers go to heaven. I don't think there's any question about that. I don't think that there's any greater purpose a person can have in their life than practicing law, feeding on, well, hopefully not feeding on human misery. And as you guys all know, I do criminal law. And so amongst everybody in the legal profession, all of whom are going to heaven, we're obviously first because we help people and we defend people, and because it's, I don't know, maybe harder. Anyway, today on the Lawyer Show, the reason I talk about that is I may have actually found a lawyer who's got a straighter path to heaven than I do. And that's hard to do. And so I want to take this opportunity to introduce my co-counsel today, Attorney Sharon Ramage. And Attorney Sharon, her office, your office is in Frisco, right?
Actually, we office in Frisco and in McKinney.
In Frisco.
Primary office is in McKinney.
Okay. And she practices in a couple of areas that I have really no experience in. And again, if you're not going to do criminal law, then you may as well do what she's doing. And we're going to have a really cool, I think, a fun talk today about a couple areas that she is heavily involved in. Number one would be special education and education law, which is a topic that we've always been too afraid to talk about it here. And simply, I'm just not knowledgeable on the topic at all. And so we're going to talk a lot about special education law with Sharon today. And she also does adoption law, which is kind of a happy law. And again, criminal law is a very straight path to heaven. If there's a faster one, it might be adoption. And if there's even a more lightning one, it might be helping folks with regards to special education type situations in special education law. And as Sharon is finding out, the Lawyer Show is all about me talking and not really letting anybody else talk. I invited her on to be the guest so we could find out more about her. So let's do that. So Sharon, go ahead and introduce yourself to JP, Kathy, and the Crew Nation.
Well, good afternoon, everyone. I'm Sharon Ramage, and I'm the owner and founder of the Ramage Law Group. And we specialize in helping families and helping to advocate for them, and especially those that are vulnerable and that cannot advocate for themselves. And just as an aside, Jeremy, there may be hope for you to get there faster, because I started my career as a prosecutor and got into special education law when I stopped doing criminal law. So that was like the next path.
Well, you went on the slowest path, being a prosecutor, to the fastest one. Not that I love my prosecutor friends, but they're behind us in line. You understand?
Well, I think there's an even faster path, and I would say it would be the siblings of children with disabilities. Those there is a special place in heaven for these families and for the siblings in particular, because of the amount of compassion that these children grow up with, and their helper attitude, and just how they deal with adversity and protection and advocacy. So a lot of my career has been devoted to helping children, whether it was abused children as a prosecutor, and then working in custody cases. I do adoptions, but then an area that really caught my heart was special education. And when I left the DA's office, I didn't know quite what I was going to do. I had interned for a firm that had done school law, and I thought I'd just kind of go work for her. And they didn't have an opening. And she said, you really need to learn special ed. This will be, you would be a good fit. So I left my job and thought I had enough money to support myself for 90 days. So I thought I would sit in a nice office somewhere and study for 90 days, and then I'd start doing work. And I found very quickly that it lasted less than a week, and I had to just dive right in. And so that's what I've done. So people will come to me and they're like, what is special education law? And it is an entire body of the law. It's a very little narrow niche, and even within education, that is all about protecting kids with disabilities and making sure that they get the education that they deserve. The statute is called IDEA. Isn't that a great idea? It's Individuals with Disabilities Education Act. We have a lot of acronyms that we use in the field, and that's one of them. But this law was enacted to guarantee that students with disabilities have the right to a free, appropriate public education. And so, and appropriate is all very individualized. So it varies by the kid, but it places certain requirements on school districts, both from a procedural standpoint and substantive. And it all starts, I tell people it breaks down into a couple of categories. You gotta find them first. That's the identification part. Then you've got to build it. You got to build their program. And then you've got to implement it. And then you've got to make sure that they're in the right placement. And so, but it all starts with a suspicion. Maybe a child is struggling in school, having a hard time keeping up. Maybe they're getting really overwhelmed. Maybe they have autism or some sort of other emotional or behavioral disability. Maybe they're having a hard time struggling learning to read. And so all it takes is a suspicion, and the school district has an affirmative obligation. That means they don't have to wait for somebody to ask. They have the duty to actually seek those kids out, find them, and identify them. And it starts with an evaluation, which is another acronym. It's called an FIE, or a full individual evaluation. And that means the child gets evaluated in all areas of suspected disability. And
let me stop you and let me go back, because the IDEA law is not, that hasn't been around forever and ever and ever. And when we were talking earlier, you had mentioned some of the evolution of some of these laws and regulations. And you said something interesting to me, which was that it was back when you and I were in school. Of course, I'm only like 25.
Me too.
but when you and I were in school, you said that, and it was absolutely, you were right on the money, that you just go down the hallway and we just never see you all day long. How is the IDEA statute, the IDEA law? Talk a little bit about the evolution and how it came about and how long it's been around.
Okay. Well, I mean, we're talking back, the predecessor to IDEA, which was the Education for Handicapped Children's Act. I probably have gotten the words mixed up. Dates back to the 70s, but our current iteration of the law, 1990, IDEA, it was passed in response to some series of cases that all kind of started with a child by the name of Rowley, who had disabilities, but she, in spite of her disabilities, was able to make progress. It's basically the granddaddy of all the cases. And that's where we decided, what does it mean for a child to receive a meaningful educational benefit from their educational program? And basically, that's kind of where it all started. This child in particular was advancing from grade to grade. She made good grades, and her disability did not prevent her from making progress in her education or accessing her education. And so that is where the courts came down and said it's all about a floor of opportunity. We want kids to access their education. Now, we've come a long way since then when we just recently, I'd say within the last 5 years, the Andrew F. case came out from the U.S. Supreme Court that said it's really about more than that. We've got to do something more than have the bar set so low for children with disabilities that it's the same thing as just letting them sit idly by and waiting for them to age out of their program. They've got to make more than merely de minimis progress from year after year. It's got to be something that, in light of their unique circumstances, is meaningful for them. And we've kind of followed that standard in the Fifth Circuit to some extent for years. But what it all boils down to is we have to have educational programs that are individualized based on the student's assessment and performance, and that they're in the least restrictive environment. And I'll talk a little bit about that. And that the services are provided in a coordinated and collaborative manner, and that the child is making academic and non-academic benefits. One of the things I tell associates that work with me when they come to me and they'll say, well, what about the education? And or when referring to academics, and I have to explain, get the word education out of your mind, because when you're talking about it, don't think in terms of academics, because education is more than reading and writing and arithmetic. It is functional skills, behavioral skills. Those all go into the mix. So we're looking at getting something that meets the child where they are, and gets them some sort of program that is meaningful to them, regardless of what their disability is. And you're right. When I was growing up, it was the room down the hall. Mm-hmm. That was what you thought of when you thought of special education. And so now children with special education, they are in general ed classrooms to the most extent they can be, but some are not. Some are in what we call a self-contained classroom, which is a classroom specifically for children with disabilities. Or in some instances, if the school is unable to provide an appropriate program, there is a continuum that we follow, and the school has the obligation to place the student there. So whether that's a private school or a residential treatment center. I have quite a few kids on my caseload right now that are in residential treatment centers because their needs are so significant that they can't be met. They can't access their education in a meaningful way within the public school system, so the school has placed them. With the goal to get them back into the school system. But that's it in a nutshell. Mm-hmm. It's about, first of all, identifying those kids. And it starts with an evaluation. Districts have very strict timelines. They've got to get that evaluation done within 60 days from the date of that consent. And then they've got to have a meeting with other school officials and the parents within 30 days after that evaluation is back. And what we're looking for, and I tell this to family law attorneys a lot and to criminal attorneys and juvenile attorneys, don't assume because you're talking to somebody and they're able to carry on a discussion with you that they have no disability. I mean, you don't know, does this child have dyslexia? Does the child have some learning differences in reading or in math or in listening comprehension? Is the child able to write? Does the child have speech issues, which aren't just articulation? Speech issues can be the pragmatic use of language and recognizing cues from people. So you could have a speech impairment or a vision impairment, which is very different from being blind. Or it could be other disabilities such as autism, emotional disturbance. But the school district has ultimately the starting responsibility to identify these kids. And it even extends to identifying kids that are in private schools within their boundaries. So you might have driven down 75 and seen some of the billboards that say child find. That is one of the ways some school districts are trying to get word out that they will look for and identify children that don't even go to their schools that are within their boundaries in some shape, form, or fashion, so they can identify them and offer them an education.
Let me stop you right there. I owe JP, Kathy, and the crew, a nation, an identification here. You're watching JP, Kathy, and the Crew Network. You can see JP, Kathy, and the Crew between 7:30 and 9 on Monday, Wednesday, and Friday. on Thursdays between noon and 1, you can watch The Lawyer Show with me, Jeremy Rosenthal. Today, my co-counsel is Sharon Ramage, and we are talking about special education law. And I interrupted you there, but I do want to kind of ask you a couple questions here that because I'm always putting my lawyer hat on, right? And being a lawyer, I'm always obsessed with money, and I'm always obsessed with the bottom line, and so I want to know, how is it that you get involved in these types of cases? When does somebody pick up the phone and call you with regards to special education issues? If you wouldn't mind, talk about how a typical case comes in and how you evaluate it and what happens.
Okay. We typically get a phone call or through our website, which is www.texasspecialeducationattorney.com, and we get calls throughout the state. And it starts with usually my child's behind, and I don't know what to do. The school isn't doing anything about it, or my child keeps getting kicked out of school. They keep calling me to come pick my child up, and they're not giving him services. And they're just at their wits' end with their with the school. Sometimes the school hasn't even evaluated the child. Sometimes they have, but they've just not done a proper program. So once that evaluation happens, there has to be an individualized program developed for that child. Sometimes it's not individualized and they need help with that. Sometimes it's just not been implemented. The school has said that they would do some things that they haven't done, and the child is falling further and further behind. Or maybe they're calling us up and they're saying, I just don't think my child needs to be in the general ed classroom, or vice versa. They think the child needs to be in the general ed classroom. What can you do about it? So that's where we start the process. And from the legal process, that is called a request for due process hearing. And it's very much, it's a procedural safeguard that's available to parents under the law. And it's very much like a trial. We file a request for hearing with the Texas Education Agency. And that agency then assigns hearing officers. I was a hearing officer for 13 years, one of the many gigs I did in this field. And it either goes to a private hearing officer or to the state office of administrative hearings. And then it gets docketed, and it's a very quick hearing because we don't want kids to go too long without their educational services. So start to finish, about 75 days, unless there is a real good reason to get it continued. But the hearings proceed just like you would at the courthouse. The rules of evidence apply, the rules of civil procedure apply. And the reason we're going to hearing is we're asking the hearing officer to find that the school district denied the child an appropriate education, and ask the hearing officer to do something about it. So that do something about it could be, we put on evidence about what the child's program needs to look like within the school district, whether the child needs a different placement, or whether the parent is entitled to reimbursement for a private placement that they've had to go get, because sometimes parents are so desperate and they pull their child out and place their child privately and seek reimbursement from the school district. And so we have many of those types of cases. And so it's a very quick process. Most of these cases resolve in mediation. The statute is what we call a private attorney general statute. Very much like other civil rights statute, which means there are attorney's fees that can be awarded if a parent is successful. And I knew that would get you fired up.
Well, that's good stuff. And I think that people, again, sorry, I cut people off. It's what I do. I don't think people understand how important the attorney fees are in a statute like this, for the reason that you probably deal with a lot of folks that it's cost prohibitive to come out and hire a lawyer on something like this. And so,
absolutely.
So the trigger is that, and do you take these cases? Can you take a case like that on contingency? And I don't know whether you can or you can't, and obviously you would know, but that would be a very, very important hammer that you would be able to utilize to get into the case and to help enforce these things.
Right. We work with families. I think it's good for the parents to pay something, right? Even if it's just a small nominal amount that they can afford, because it gives them some ownership in it. But the bulk of our fees are paid on the back end. We're either negotiating fees at the school district with the school district at mediation, or if we win, we present a bill to the school district for payment, and then we may be litigating fees in federal court. But ultimately, it is, the parents are typically paying a very small portion of our fees up front, if anything, and then we're getting paid typically out of the mediation. That's a part of the agreement. We still have to do hourly billing because that's the current state of the law. Making just the lodestar analysis that we're a reasonable fee and at a reasonable hourly rate. So we still submit hourly billing fees, but they're typically or what's negotiated at the time, typically at mediation. Almost all of these cases, I mean, I say that I've got a couple getting ready to go to hearing, but most of them are resolved quickly because the school districts, usually by the time it's escalated to the point that we're getting me involved, they also are escalating it to get their attorneys involved. And it's frequently the first time anybody's taken a critical look at the case. And I pride myself with being, and others in my firm, with being pretty creative at coming up with creative solutions that get our kids' needs met, but also are palatable to the school districts. And so that's what we do. But it's a big hammer.
So what I was going to say was or ask you about, so you guys get involved in, really, it sounds like on both ends. Let's say a child has not been properly diagnosed. Let's say the school district has not put in the resources that they're supposed to put in for this child's needs. You can come in and help make sure that the school district is doing that on one end, or on the other end, if they have done it, but mom and dad say, no, our child needs to be more in the general, needs to not be so much in these programs. You guys do that as well.
Absolutely. Now the child might very much need special education, but they just don't need to be like in an isolated classroom or in a restrictive setting. Maybe they need access to general education peers and the curriculum. It really kind of runs the gamut, really, on those options. Sometimes we're involved in just going to IEP team meetings with families and trying to get it worked out at that level. But more often than not, we're filing for due process and going to mediation. And the private attorney general component of the statute makes this a very meaningful hammer for families, because the school district is at risk not only of paying their attorney's fees, but paying the attorney's fees for the parents if they lose. So it gives an incentive to everyone to try to roll their sleeves up and get things worked out for the kid.
What would you say is the most difficult or undiagnosed problem that school districts are missing?
It comes in waves, because what we noticed, I was a hearing officer up until 2015. And after I left in 2015, we were noticing calls into our office. And I'm like, people were saying the schools were refusing to evaluate at all. And their reasoning was, well, the child doesn't need it. Well, doesn't need special education. Well, that's the question of an evaluation. Does the child, because of their disability, need special education? Well, the Houston Chronicle launched an investigative series back in, I believe it was in 2016, 2017, that found that Texas was seriously under identifying eligible students. Like the nationwide average is about 14% of the general population would have special education services, and it was below 8% in Texas, and there were some incentives. So we've seen some changes since then, but I see a lot of times kids, dyslexia, of course, is something that is not picked up real early, or maybe it's picked up early, but they delay on evaluating. Believe it or not, a trend that we're seeing is autism not being picked up early enough. I've had kids in high school that or that have autism that has never been picked up, and it's been right there before them all these years, but they've seen the kid more as a behavioral issue because maybe cognitively the child was still on grade level with their performance. It's just those behaviors start rearing their ugly head at certain like middle school and high school, and that's when they're kind of finally realizing, hey, this kid does have a disability. Believe it or not, one of the most heartbreaking cases I ever saw was a kid that was legally blind that nobody figured out till he was in the 8th grade.
Wow. I'm going to ask a question. Let me do this first. You're watching JP, Kathy, and the Crew Network. You can watch JP, Kathy, and the Crew between 7:30 and 9, Monday, Wednesday, Friday. You're watching The Lawyer Show. We are on between noon and 1 on Thursdays. I'm your lawyer, Jeremy Rosenthal. Today, my co-counsel is Sharon Ramage. I'm going to ask you a question that I am frankly afraid of the answer, and I mean that in all sincerity. So it's kind of one of those questions I'm going to ask, and then I'm going to put my hands in front of my eyes and then watch you answer through my fingers because I can't think that the answer is going to be very pretty. But what are how has the pandemic and the COVID-19 issues, how has that affected special education?
It's heartbreaking. I've had kids on my caseload that have autism, and they're stuck at home and being required to just log in online to get their education, and they can't. First of all, I had one kid that one of his IEP goals had to do with his behavioral goals was accessing bad things on the internet, and he was left to his own devices with the computer. You have kids that get overwhelmed really easily. So you and I can get overwhelmed pretty quick because I'm looking at you and you're a little bit bigger than a postage stamp right in front of my camera. And imagine you've got a child that has sensory issues, that has hard time staying still, hard time getting around, moving. These kids are really falling behind between the cracks. And I've had kids that they're general ed peers. I have one family. She has a child in general ed that gets daily Zoom calls with her, Zoom classrooms with her teacher. The child that has the disability gets nothing. And so TEA has told school districts they're to offer some compensatory services or makeup services for these families. But what really frightens me and what I see is parents don't know what they're giving up. And so school districts come in and their attorneys have drafted something for them. And these parents don't know this, saying, oh, this is what we're doing to make up for everything you've lost in the last year. Just sign here. And they're signing away their rights. And there's only a 1-year statute of limitations under the law. So it's, we're now going on almost a year since we've been down. And so a lot of what's happened in the last year is, it can be almost lost. So that's been the hardest thing, is getting that message out to these families that their kids still have a right to an education.
Yeah, it's totally, it's heartbreaking, and you can't think that everything that's gone on with the pandemic, it's hard for good students to, depending on their age, or not even depending on their age, it's hard for good students to really be able to weather this storm. Not only that, a lot of times in a lot of these districts, I'm guessing you would think that the school adds a critical layer of infrastructure because you've got working mom and then working dad, and so then you take it all and it just it's just so worrisome to think how far behind some of these kids are falling, particularly those with learning differences.
Right. And like if you have a kid that's on the spectrum that needs significant behavioral support, they're not getting that on a Zoom conference call, and they're not logged in. And so they're basically saying, good luck, parents, we'll see you when this is all over. And these kids are really losing out. And it's very heartbreaking. There are some programs that are pulling it together. There are some private programs that are doing really well, that are meeting in spite of the pandemic. Another area that we've seen some real deficiencies is not evaluating kids, because you've got a lot of schools saying, well, until we're back in brick and mortar schools, we're not going to be able to evaluate. when the law says you got to evaluate anyway, just figure it out. And there are some testing instruments that, since they say, well, they're not designed to be administered with a mask. Well, go ahead and administer it, but just put your limitations in your report, but at least try to figure out what's going on with the kid. And that's not happening.
And it seems almost impossible. I think I was watching, I don't remember a lot of things. 60 Minutes, I think it was, that was doing a story. This has been several months ago, but some of the school districts, some big school districts they can't count. They don't know how many homeless kids they've got. They can't put tabs on kids at all. They can't figure out where they are. They can't figure out if mom and dad moved, or why these students aren't online, and so what a nightmare. And then just to not even be able to find your students, and then on top of that, they're supposed to evaluate whether or not there's a learning deficiency. It seems like a really tall order, particularly for some of the school districts that don't have a lot of these resources.
It is, and and some districts legitimately don't have them, but there are some that just don't try to. That it's an out, what I'm saying? And I do think most educators want to do the right thing. Unfortunately, the bureaucracy within our educational system doesn't always support doing the right thing.
Well, that's where lawyers and lawyer fees come into play, because that's why they got to watch their flank, because here comes Sharon. And her legal fee that they have to pay by statute.
Yep.
Bang.
Yep. And they need people to hold them to task. And but ultimately, I want my kids to just get their needs met. And I was talking to a parent just the other day, and it's real easy to say what do you want, and they say, well, I want a program for my child. But I said, what do you really want? And she just started crying, and she said, I just want my child to feel respected by his teachers. And that's really, we all want the same thing for our kids. We want them to feel respect. We want them to feel love. We want them to see it in whatever way they can. And kids with disabilities are no different. And that's why we have this law.
Can you talk? Okay, so let's shift topics here just slightly. Actually, this is a major shift. Let's talk a little bit about adoptions, because you practice in the area of adoptions, and again, that's not something that we've typically talked about on the Lawyer Show. On the Lawyer Show, we try to target difficult, macabre, awful. We try to show JP, Kathy, and the Crew Nation the true demonic nature of what it is like to be a lawyer. But this is happy law. Adoption is happy law, and it's something that I just don't ever get to talk about much. So talk about adoptions.
Okay. Well, it's near and dear to my heart because I'm an adoptive parent. And I learned adoption law from, she's now deceased, Susan Paquette in Fort Worth, and she has long been considered, it's just an icon in the field. And I got into this actually before I adopted kids, but my children were adopted from China as infants. And so ever since then, a substantial part of my practice has been adoption. And you say it's happy law, but it's not easy law. And sometimes you get to the happy ending, but there are some difficult roads along the way. And so what I hate to see is cases that come in and maybe somebody's dabbled in it and thought that and it left the family at risk. And so where we try to get that fixed. So it starts out sometimes with the child that's already eligible, and sometimes the family comes to me and they've found this family that want them to adopt their child, and we still have to terminate those parental rights, and we have to have a reason to terminate those parental rights, even if it's involuntary. Preferably it's voluntary, but even if it's involuntary, sometimes we're able to go ahead and go in and do that and then handle the adoption. But there are a lot of hoops to jump through, but it's so worth it at the end when you're doing that adoption prove up with the family, and everybody's happy. One of my favorite stories to tell is a case that I did in Judge Willis's court. And the parents told a harrowing tale. She was originally from Iran, married an American citizen here, and she still had family in Iran. and they found these children at an orphanage in Iran. And they were, I think, 9 and 10 by the time they were adopted here. And the harrowing tale that she told about going over to Iran without her husband, because she was afraid if she took her American husband there, they would not come back. And she was there for 10 months, going through the process to adopt these kids. Could not find anybody to do a new birth certificate for the kids because there was no character for United States of America on the computer or the typewriter that they were using to reflect the children's birth, what would be their adoptive father. And she had to, no judges would sign off on it. She finally found a judge that she went to almost in secret, and then flew to Kazakhstan, I believe, to get her, no, she flew to Turkey to get the passport to get the kids out of Iran. And just the harrowing tale and the tears of joy for these kids at their prove up, because they knew what they were leaving behind and what they were embracing here. And they're not just having a new family, but having a new country. And it's an experience I will never forget. And I've always joked about I need flags all over my office for every country I've handled on international adoptions. But we have very similar tales on the domestic side as well. So it is a very, very rewarding practice, but not for the faint of heart, because you can miss some things and it could leave people in a lurch.
It sounds like I think it sounds like there's some pitfalls here that you really wouldn't necessarily think are there, and not the least of which are, I mean, I'm not licensed to practice in Iran, but I don't, I can't think that that's not a problem. I can't think that that's not an issue. That I mean, I'm guessing they have something to say about this. Depending, and each child is different. Each situation is different. Each issue is different, and those sound like they can be kind of incredible hurdles at times to overcome.
And they can be. Fortunately, to adopt internationally, there's compliance that has to be done by the Hague Convention, and agencies have gotten really good at. There are certain agencies that work with certain countries that of giving you everything. The big key with the international adoptions is making sure that you're either readopting the child in the United States or that you're doing an original adoption. Is just making sure some countries will not allow the adoption in that country. They just place with the agency, and then they come to the United States, and it would be just like a CPS placing with a child. You're doing just a straight up adoption of an eligible kid, but you need to make sure you're doing the right process so they can get their citizenship. And on the international side, another pitfall that people fall into is getting the wrong type of relinquishments. They can either be revocable for 11 days, or they can be irrevocable for 60. And if you do one that's irrevocable for 60, there's a case out of Fort Worth from years ago where the lawyer, because after that 60 days pass, parents can go revoke. And if you have it terminated on them, and the lawyer didn't get around to terminating within the 60 days, then the birth parents went and revoked. There was a lot of litigation. Those adoptive parents were heartbroken because the child went back to the parents. I had a case come up on my caseload once where it was a teenage girl that relinquished, and the lawyer had done an 11-day revocable, which I would never do on a young girl, because they're going to change you want more time to get into court to get termination, because they change their minds so frequently. But on day 11, she revoked. And so we had the hard process over that. Ended up with a good result with my client being able to adopt the child, but we had to get over that termination hurdle. Another pitfall is you want to make sure nobody's doing anything to give anything of value to the birth parent. I tell my clients, don't even give chewing gum. You do not want to be in a position where it appears that you're buying a child. That's illegal. And I don't place children. There are adoption agencies that do that, or you can do privately. And then finally, another area for pitfalls is the interstate compact for the placement of children. If you are interested in adopting somebody that the child is out of state, you actually have to go. There are a lot of hoops that you have to jump through before you bring that child across state lines. And you need to make sure that the interstate compact has been complied with and that the termination was done in the original state, and then the child brought lawfully into the state of Texas to complete the adoption here. But I think I got it down. I've been doing this a while.
It sounds like it. So we have an exceptionally rare occurrence on the Lawyer Show, which is we have questions from some people who are viewing, I think, unless these are just from JP, who's sitting right here today. He's got questions too, but these are from the World Wide Web. Really? Okay. It doesn't happen much, but they're for you. Question number one: What is the need? What is the need domestically for adoption?
What is the need?
Mm-hmm.
I can't tell you right off the top of my head what the numbers are. I know there are a lot of children within the foster care system, and there is a high level of need for kids within the foster care system to find forever homes. I wish I could give you the statistics, but it's pretty significant. I'm sure Judge Wheelis could tell us exactly what that number is a lot quicker than I could. But it's not just CPS cases. It is, I think there's a need out there for just mom and pops and aunts and uncles that maybe adopt a relative's kid. I mean, there are a lot of situations out there that I have seen where people probably really should be adopting the kid that they're raising. They've just never gotten around to do it. There's an informal placement with family, but I firmly believe that kids have the right to call whoever is raising them mom and dad. I think it makes a difference, and so but the need is pretty significant.
Another question that we have is, if you want to adopt, where should you go?
Well, there are many domestic adoption agencies. You can also get certified as an adoptive parent through CPS or the Texas Department of Family and Protective Services. You can either be licensed as a foster parent or as a foster parent with the look to adoption. It's called foster adoption, or there are many agencies within, and I'm not to promote any one agency or over the other, but if somebody wanted to call me offline, I could maybe steer them in the direction of that. But there are several really reputable agencies in this area, some affiliated with churches like Catholic Charities or Lutheran Family Services, some that are not, such as Gladney, and I think there's Methodist Mission Home. I mean, there are many adoptive agencies that can help you. And I'm not vouching for any agency over the other. I feel like I have to give that disclaimer.
You're watching JP, Kathy, and the Crew Network. You can watch JP, Kathy, and the Crew between 7:30 and 9 on Monday, Wednesday, and Friday. This is The Lawyer Show. We're on between noon and 1. I'm your lawyer, Jeremy Rosenthal. Co-counsel today is attorney Sharon Ramage. The topics we have been talking about today have been special education law as well as adoption, and we were talking about adoption. And I think one of the questions that I had, and you've kind of addressed sort of a lot of this, but one of the worries is that mom and dad or the adoptive or the birth parents have second thoughts or second doubts. There are ways to secure or seal those off that you were talking about, and you talked about one instance where it wasn't done properly. How much of a concern is that?
If the termination is done correctly, for example, you've gotten in quickly to do the termination. The law is once that adoption's happened, it can't be collaterally attacked after 6 months. So I tell my clients, you're getting past that 6-month window, you're good. Now, there are some exceptions to that. There's void adoptions and there's voidable adoptions. And you want to make sure, for example, if there needed to be compliance, and I think there's been some litigation on this recently, so it might not be as big of an issue as it once was, but with the Indian Child Welfare Act, that there's special hoops that you have to jump through on that. But for the most part, provided provided everything is done properly and there has been a voluntary relinquishment, then you get past the 6-month window, you're good. But those records do get sealed, and just had to unseal one for somebody because they gave away all their certified copies. So we had to go down to the courthouse and unseal their record to get it. But they do get sealed, and they can be opened later on if somebody wants to register to try to locate their birth parents. That can happen. But more and more, though, you're seeing open adoptions, and I've done some of those, and those fall varying degrees. Some of it's just knowing where the person is and having some way of communicating, whether it's a PO box. Some are more open in their presentations, but where there is actual ongoing contact. I feel like it's a pretty safe process as long as that termination gets done correctly and timely.
So an open adoption is where birth mom and birth dad play an active role, and it's is that what that is?
It's a number of it can be. Sometimes open adoption just means that there is a PO box to send cards and letters to. Sometimes it is, you know what, I'll meet up with you once a quarter, and it's all based on the good faith of the parties that are involved. But a big number of adoptions, they all know each other because it's family members or friends of family that are stepping in to adopt a child of someone else, and that either is a family member or a friend. And so there are a whole lot more varying degrees of open adoption than I think we even know about, because a big percentage of adoptions happen with people that are known.
Mm-hmm. What is the difference between being a foster parent and adopting?
Well, a foster parent, you're taking care of the child while the child's parents are trying to get their act together. If it's a CPS case, and CPS has a limited amount of time to provide services to the families, and the families have to work those services plan to be reunified. And that is the goal of CPS, is to reunify those families. So there is no guarantee. You tell foster parents, when you're becoming a foster parent, you're opening your heart to be broken. You're going to love these kids, you're going to take care of them, and then you're working towards letting them go. Where if you're adopting, those rights are being terminated, and you are going to become the forever family for that child.
Okay. And talking about a criminal law overlap, because we can even go back to the special education part, because there are overlaps too with criminal law there. But with adoptions, and again, we talk about termination. So explain to everybody at home, how does a parent have their rights involuntarily terminated? How does that work?
It can be something as failure to support the child within their ability for the year leading up to the termination. It can be leaving the child with an intention not to return and not supporting that child. Or it can be what we call D&E grounds, which is engaging in conduct or that puts the child at risk of substantial physical harm or emotional harm. And so, or they actually did cause that harm. Engaging in conduct that is a child abuse offense or a sexual abuse offense against a child. They're using drugs while pregnant and causing the child to be born drug affected. There are a number of certain grounds that one would have to prove. I always tell my clients, if they're coming to me and they're wanting to adopt, but the parents aren't relinquishing, that is kind of the hard. We still have to have the grounds, because more often than not, the easy ones, the ones that have harmed the kids, that have abandoned them, they've been gone for years, those are not the hard calls. The ones are where the parents are in and out and they're doing just enough but not enough, and those get to be a little bit more problematic. But you've got to prove those grounds.
And that can be in front of a jury. That can be they have a right to a jury, and I think
they have a right to a jury trial on the termination issue. And it's really two separate lawsuits. I mean, if the child's not eligible for adoption, you have to file that termination suit first, and then get the rights terminated, and then you proceed to a separate adoption.
And that can be that can be a real roller coaster, I would think, too, for a family, because you don't, and some of the terminations are they're no brainers, but then on the other hand, you get those that you just described there, that mom and dad are kind of getting their act together, but not really getting, like you said, they're just, and you're almost betting, it would seem to think, if you're trying to pursue an adoption of kids that fit in the middle of this, tragically, you're almost betting that mom and dad can't get their act together.
Right. And sometimes it is a matter of a parent being in jail.
Mm-hmm.
And I've typically told my clients, if one parent is in jail, they're not going to relinquish. We will be having a trial.
Mm-hmm.
Because they'll just get somebody to help them, and they'll show up. They're not entitled to counsel, but they'll show up in some way, and we'll get there eventually. But more often than not, it's like the family member, like the aunt or uncle that wants to adopt their niece's daughter, and they're in and out, not doing quite enough. A lot of times, an alternative for those families is go ahead and get custody first. Do a conservatorship case first. Have them in your care for a year, and then eventually we'll get there. But we'll start out this way. But contested terminations are not easy on anyone.
No, I wouldn't think so. So there are some intersections there with criminal law. Obviously, in criminal law, our clients, some of them have these issues on the side, right?
Right.
They have these issues that they're facing the criminal charges on one end, but on the other end, they're also facing a potential termination. And to kind of circle back to the special education law and that part of it. Because when we were talking earlier, I kind of felt like, and doing juvenile law, I do some juvenile criminal cases. That may be how a special need is diagnosed, right? Because of the acting out or because of some type of issue. And we've seen cases where, and as you were describing to me earlier, where there could be a criminal mischief. In other words, you have a student who is at school and acts out inappropriately or violently, or damages property, or maybe even assaults another student, and that's
or a teacher,
or a teacher, and that's how we figure out that there are special needs. So, can you talk about how the intersection of criminal law in really either area?
Okay. Well, first of all, in special education law, students with disabilities, sometimes they're known disabilities and they're acting up, but the law says that they cannot be sent to a disciplinary placement or the alternative school for conduct that is substantially related to their disability. So if, for example, physical aggression is a component, or is a known behavior of a student with a significant emotional disability, or say autism or ADHD, if they get overwhelmed and you know that that's how it manifests itself, then the behavior, and they strike out when they're cornered, then the behavior is going to be likely substantially related to their disability, and they cannot be sent to the alternative school unless it's drugs, aggravated assault, or weapons. And that is where we see a lot of litigation, because it's easier sometimes for teachers to just get the child out of the classroom. And so we send to the alternative school. So they get a really fast hearing, special education hearing, and a return to their campus. Another area where it comes for those that are listening that practice in this area, like in criminal law or juvenile law, you need to know what to ask for. I mean, don't assume that your client doesn't have a disability, and don't assume that the parent even knows that it's a disability. I mean, if you ask their child, do you receive special education? They're like, no. Well, do you go to meetings with the school? How frequently? And what do y'all talk about? And they're talking about their educational plan. And sometimes parents don't even know what they have. So you need to ask for school records and get the child's special education records, so you can see if that child has a disability. I can guarantee if they're being shipped out to the JJAEP, that's the first thing that they're requesting is those records from the other school. So attorneys need to get those as well. So that's an area where there is a big overlap. There's actually an overlap with special education law and adoptions as well, but that's another, I could do an entire show on that.
All right. Well, let's ask JP if we can. Do we have another hour? We got 5 minutes.
You've got another hour.
Hey!
No, just kidding.
No, we don't have another hour.
You got about 5 minutes, though.
I don't know that that's doing it justice, but go ahead. Talk about some of the overlaps. But talk about some of the overlaps between criminal law and special ed and adoption.
Oh, okay. Comes up very frequently. A lot of times you have kids, and what people don't understand is that adoption creates a loss, no matter if that child was adopted at birth or if that child was adopted much older. So if you have a child that has some attachment issues, or say they were adopted and they were born drug affected, those are issues that are going to present themselves frequently. These kids will receive services when they're in school. And they, recently did a case for a kid that had significant reactive attachment disorder. She was eligible in school for special education services for emotional disturbance because of her reactive attachment disorder. The school couldn't serve her because her needs were so great because of that. And it really took somebody understanding adoption, attachment, not just at the school level, the psychologists, the lawyers, we all got together, figured it out. There was a great placement for this kid out of state that was a residential placement, so this kid could get skills that she needed to survive once she was out, or she was just headed for probably jail for when she got out. So those adoption-related issues carry over, and they carry over for a long time.
Do you miss being a prosecutor?
Nah, sometimes, but not real. I think I've been out of it too long. I had some of the best years of my career were learning to try cases as a prosecutor, and I was a child abuse prosecutor for 3 years.
Were you in Collin? Were you in Collin County?
Tarrant
County. Okay, that's the friendliest place on the planet to practice law.
And it was under Tim Curry.
Okay.
He was one of the best. And I think I did good work. I was ready to move on. I think I had there are people that talk about being career prosecutors. That did not seem right to me. I think I did my part, and it was time to pass the baton to somebody else to do theirs. And then getting out and seeing a different perspective, because there are two sides to every coin. Actually, I always tell people there are multiple dimensions to every coin. They're not
for sure
flat on each side.
Yeah, and and I slightly joke about Tarrant County. So are you a Baylor lawyer?
Yes, I am.
Oh, really? Oh my gosh. And we only have a minute left.
Yeah, sorry.
Sorry,
Sick'em Bears. You're going to have to put it to
I
bed
know,
for now.
It's a lawyer show tradition for me to make fun of practice court. So we have a minute for you to defend practice court. But the other thing that's just right below that is Tarrant County, because Tarrant County is I joke because I'm a Collin County lawyer. That's where I'm based, and Tarrant County, everybody who's there says, "Oh, it's the friendliest place. Oh, it's the friendliest place. Oh, it's the friendliest place."
Unless you're not from there.
Thank you. and when they get to not be friendly is when you start winning. That's when they get to not be friendly anymore. But anyway, I guess we don't have time for you to defend practice court because we're at it. No, I'm kidding. You have 30 seconds. Yeah. So. Okay. So tell JP, Kathy, and the Crew Nation what practice court is, because I sit here and some of my best friends went to Baylor. Lawyers that I hire to get me out of hot water if I ever land there typically have Baylor degrees. But tell everybody what practice court is.
It's 3 quarters, a full year of just having your feet held to the fire every day. When most law students in most law schools are coasting during their last year, you're getting put through anything worse than a lot of schools have in their first year. It is where people are weeded out. You learn to think on your feet, because if you don't, you're going to get kicked out of the classroom. And it's more than just learning the nuts and bolts of having to try a case in a practice court. It is constantly being grilled and being called up and having to think on your feet.
Well, JP is playing the music now, so he's about to yank me out of here. I really wish you had more time to be able to defend properly practice court in the way that it should be. Had I known this, and I should have asked you right at the beginning, but had I known this, I would have given you even less time to defend it. So anyway, this has been delightful. This has been a lot of fun, and so thank you for being with me today on the Lawyer Show, Attorney Sharon Ramage, and I guess we'll see everybody next week.
Yeah, thanks. I'd love to come back. Thanks a lot.
All right, bye-bye.
Bye-bye.
Thank you very much. That was a lot of fun.